If you'd like to take your seats, and we'll start up. A number of the issues which are being discussed here today obviously are not new, and there has been discussion in some of the lawyers' mailing lists that are carried on the internet. Two of them that I follow most closely, one is Net Lawyers, which is a US one, and one is Sea Salt Talk, which is a Canadian one. If you're interested in subscribing to Sea Salt Talk, very simple, just send an email message to majordomo@io.org. That's io.org. I think org is a single word now. Majordomo@io.org, and the command is, in the body of the message, subscribe. Sea Salt Talk. It's all lowercase letters, and there's a hyphen between Sea Salt and Talk. And then give it your real name. So I would type in subscribe, Sea Salt Talk, Louis Eisen, and you'll get a message back very soon. Let you participate in the discussion. Lawyers from all over Canada and whatnot who are on the internet are discussing all the issues that are facing us now, and certainly there's lots of mailing list resources that are available to you. Speaking of mailing lists and publications, I'd like to call on our next speaker. Actually, Malcolm, you were introduced in absentia. Yeah, I told them wonderful things about what you're doing.
Thank you very much.
Please.
Thank you. What you're going to hear now is at an entirely different level of expertise. We've heard from experts. I am just a putzer in this thing. So this will be very personal, if you don't mind, and subjective. What I want to tell you about is some of my own experiences in dealing with this. They may duplicate some of yours. I may be behind you. I may be ahead of you. But let me just tell you what I've tried to do with this stuff and how it's worked out. In 1994, for some months I'd been hooked up to CompuServe, and I lusted to get on the web, the internet, and I was kind of afraid of it. I couldn't seem to get a handle on how to do it through any material easily available to me at that time. That's my fault. The material was out there, and I just didn't get into it. The turning point, though, was Lewis's program last January 26, 1994. It was the program Internet for Lawyers, and I attended that program. Got his book, which is now filled with notes and scraps, and that led me to hooking up with an information server, which worked out fine. I had a little problem at the beginning, and Louis was kind enough to give me some information directly through email, wasn't it, Louis? I think it was. It was very kind of him to do that. So I started clawing my way up the learning curve, because a couple of things wrong. At that point, CompuServe did not have a general internet connection. It does now, and so do other specialty servers like America Online and Genie, but these things always seem to me a little too sanitary and restricted, and I believe they are probably more expensive than dealing generally with an information server. The difference, this is not my definition, but I like it very much, the difference between an organization like CompuServe as access to this information and dealing with the World Wide Web was put to me as the difference between a department store and an open-air market. You know, you go into a department store or a brilliantly lit supermarket, everything's clean, everything's laid out, it's on the shelves. Pretty soon you can find out where it is. Somebody will tell you where it is. You know, you got some help there. But the web is, I think, like a huge, sprawling, dirty, open-air market, for the most part. Everything is there. Everything's there that would be in the department store, and perhaps more. It's not organized, for the most part, but you can find it. You know, if you want to wander around in the market for a while. And what the department stores have done now is they've opened a back door. See, you get into CompuServe, you go out the back door of CompuServe if you like, and that'll take you into the market. But I must say I do prefer dealing with the web rather than the specialty servers, and I don't use CompuServe much for anything anymore, though I am still a subscriber. For about 17 years, a little more, I had been at first publishing with a colleague publishing, and then later, after we gave up the publication side to Butterworth's editing, co-editing, a print publication called the Ontario Family Law Reporter, which is still running. After 17 years or so, I got a little tired of doing it, and my co-editor was happy to take over the print side of this thing. So we talked about it, and it was decided I would try to set up an electronic companion version of this thing, which we would call the Ontario Family Law Bulletin. And the idea was not to duplicate the print material, not at all, but to perhaps complement it, perhaps contradict it, perhaps use the bulletin, the electronic bulletin, for more subjective stuff. And we hoped that maybe we could start some dialogue and feedback through using the bulletin. Initially, I had significant problems in configuring and using the Access software. What I found is if you're going to use freeware instead of a commercial product, there isn't a lot of help that is easily accessible. There are no manuals for freeware, of course. And ultimately, though, I got coordinated using Eudora as an email server, and I found that quite satisfactory. And I started using Netscape 1.1 as the web browser. And then I looked at what Usenet groups were out there, thinking, well, where are we going to post this thing? Lewis's original book had a huge list of Usenet groups, and a Gopher file that is listed in my material that gives you an immense list of law-related mailing lists all over the world. So I decided that we'd post this thing to cam.legal, which is sort of at the low professional or high public level of information and exchange, and is not, it's not technical. It doesn't deal with internet or computer subjects. It deals with anything people want to put on it. And the other one, I put it on an American group called MISC.legal.moderated. And I continued to put it on CompuServe. There's a legal forum, law and the library section. So this started in April 1995. It's been running since then. A little after that, Simon Fodden, who's a professor at Osgoode Hall and is their internet guru, spotted the Ontario Family Law Bulletin, and he asked if he could use it on the Osgoode Hall homepage. So, of course, I was honored and delighted that he would do that, and he does. I regard that as the prime site now for the Ontario Family Law Bulletin. I think it's very well presented on the Osgoode Hall homepage. I think it looks very good. And if anybody's interested, at page C1 in the material, there are 2 issues of the Ontario Family Law Bulletin, and the Osgoode Hall homepage address is there. The Osgoode Hall homepage is a terrific homepage with all kinds of law-related information. The last couple of parts of the address, where it says fambull/oflbhome.htm, are of course for the bulletin itself, but you can get on the Osgoode Hall homepage simply by stopping at the word Osgoode. The motivation for putting out the Ontario Family Law Bulletin was, of course, a mixture of altruism and marketing. experience in doing the print newsletter for the last 17 years or so meant that I was reviewing pretty much every month all unreported family law decisions. Perhaps that's not quite fair because a lot of them are rubbish, and it means at least looking at them and throwing out 80% of them and looking at the other 20% and then abstracting a fraction of those, but at least there's this huge flow of information that goes through. So it was no great effort to adapt that idea to the Ontario Family Law Bulletin. And of course, if it helps the profession, if it helps the public, great, we're happy to do it. And in my practice, which is exclusively family law, there is, let me say, there is a marketing problem because one cannot really go out and encourage people to break up their marriages. So you have to find a different way to market your services, and marketing consists, I think, of maintaining some kind of a profile within the profession, within the public, and it's a delicate thing to do. So I had hoped that the bulletin would serve to do that. If you look at the November and December issues, there is a January issue since then, but of course we went to press before that. If you look at that, you'll see that it has a fairly simple format. There's an announcement at the beginning where we are and who we are. And at page C1 there is a little memo that Jeff Wilson did on the Hague Convention on International Child Abduction. It was a hot topic in the family law field. And then after that I did, I don't know, a dozen cases, which we say are cases in one sentence. It's an exercise in trying to boil down the ratio or the important part of it in one sentence. And by the time I got to the December issue, I found that I couldn't do it in just one sentence, so there's maybe 20 cases there, and they're done in 1 or 2 sentences. But I think that's the format we'll try to follow for the most part. Some kind of an essay where we've got one, or a monograph, some kind of update on statutes or practice areas, if that comes out, and we'll just harvest whatever's out there month to month. The experience, let me just go into a couple of incidental things that may help you or that may duplicate your own experience. I wasted a tremendous amount of time and energy when I decided that I wanted to go to the more advanced version of Netscape. Netscape was saying, try our new Netscape 2.0 beta version, download it now, and do it. Well, I downloaded it, and nothing seemed to work properly. It was a terrible waste of time. Ultimately, I tore it out of my machine, and I downloaded and installed a slightly more advanced version of Netscape than the one I'd started with. I think it's Netscape 1.4 that I'm running, and this gave me an awful lot of trouble in accessing my server. I'd get messages, no DNS entry, whatever the hell a DNS entry is, and it would crash all the time. Unpredictably, it would crash. Like once it would work, and then 3 times it would crash. It was driving me nuts. And after many, many complaints to my information server and wrong advice, a lot of wrong advice, I finally got from my server a technical memo that Netscape had put out. And they faxed me a copy of the technical memo, and I brought it here because I think it illustrates that there's a lot of crap out there, and when you see these advertisements that say, sign up with us, and in 10 minutes you'll be surfing the net, right? I just don't think that's true. So at the risk of maybe boring you a little, this is what Netscape itself put out and that I got from my information server. I'm not going to give you the whole thing, just the beginning. The heading is Troubleshooting General Protection Fault GPF Programs. GPFs are what crashes the whole damn thing. Okay? And this is a memo from July '95. Listen to this. Microsoft Windows can sometimes be prone to a wide variety of crashes, glitches, GPFs, and other assorted weirdness. Here's a list of things to try if you're seeing those sorts of problems when you run Netscape. Right? Then it goes through some technical stuff. First, edit your netscape.ini file and change the use async DNS line to no. What are they talking about? This sometimes works magic in getting things to work. Since some configuration of Windows networking software will fall over at the first sight of asynchronous DNS. Also, if you do this, make sure you set max connections to 1. Both of these settings are in the network section of the ini file. It says you should edit your config sys file to have, and then it tells you what should be in there. Okay. So I get this message, and I followed by rote, simply by rote, the instructions to modify and edit the Netscape INA file, which of course I'd never previously considered. I didn't know it was there. And I did the config sys file. I didn't understand it then, and I could never in my life have figured it out for myself. I don't understand it now, but it works. See, it works. The point is that there is arcane technical information around and very, very little help. If my server had not provided this memo, I must say I might have given up on the whole thing or gone to another server or, I don't know, melted down the computer. It was driving me crazy. So I don't trust the simplistic advertising about how easy this is. And I also think that many, many products are released with inadequate testing. Some of them are outright frauds, I believe. There is a recent example of a product called SoftRAM. SoftRAM is a very inexpensive memory doubler. It's just a disk. You put it in your computer, install it, it goes in smoothly, and it doubles your random access memory. The problem is it doesn't work. And it's been the subject of investigation and a general recall. So if anybody bought it, you can get your money back. I think what are they, synchronous software, what are they called? I think they're in serious trouble on this thing. That was despite a very big ad campaign. I gave an example of Netscape 2.0, the beta version, forget it. And on one of the mailing lists that I'm on, a lawyer's mailing list, there was some very enthusiastic comment about a program called WebOdex. WebOdex, okay? Download WebOdex for free, and what this thing will do will organize your bookmarks. Now, if you're anything like me, you got a couple of hundred bookmarks by now, and you got them somehow organized. But the idea of having a kind of a bookmark editor and a nice little page that sets them out by subject, and you flip them around and change them and organize them, is great. It's wonderful. So I downloaded WebOdex, and it's a lot of crap. It just did not work. This was a beta version. I have to say, fairly, it's a beta version, and as far as I know, they have never come out with a better version. I was looking at a copy of Toronto Computes. I like these papers. They're a lot of fun to read, and there's very useful information in them. So here, Toronto Computes, January 1996. There's a review of Netscape Navigator 2.0, stretching the web, and it's a very enthusiastic review. And I want to tell you, I don't believe it. So my view is that one should take an extremely conservative approach to new products. I think they are hyped. I think they're put out with inadequate testing. I think there's a lot of pressure on the manufacturers that is passed on to the public to upgrade. You know, you're always looking for something that's faster and has more services and does this job better. And there's a lot of competition out there. But my view from now on is I'm going to be extremely, extremely conservative about these things. If I got something that works and I'm comfortable with it, I'll change it maybe, but only when it's proven to me that there is something better and something that I can handle. Okay, so what has happened with the bulletin? There is some feedback from the bulletin, but there is very, very little evidence that it has a useful marketing function. I think the same about lawyers' homepages, by the way, and I see stuff on the mailing list about how important they are, whether you actually get clients from them or what they do. I think mostly what they do is feed egos. I think there is extremely little evidence that, that home pages produce any business at all. What happens from the Ontario Family Law Bulletin is I get some requests for reference material. I was contacted by an American agency primarily engaged in pro bono work for disaffected fathers who asked if they could use me as a reference point. And I don't think any new client has arrived because of the bulletin. I heard the remarks, and that's great. You know, good luck to anybody who can do it. But for me, I don't think it's happened at all. I get some feedback from colleagues, and in one case a judge who's made some very kind remarks. I'll share something with you a little later. So what I find then is I like to do it because I've been doing this sort of thing for a long time. As I say, it's not much effort to do it electronically, and if it helps, fine, and if it produces any business, also, that's fine, but I certainly do not depend on it. In the material, at the C section, there's, beginning at page C9, I put in a list of just some of the bookmarks that are in my machine. There are some of the search engines there, as you'll see, that I found useful. I really like open text, and I use it a lot. The last one there, the Gopher, you see that thing, Law Next, Use Chicago, et cetera, that's a guide to law-related mailing lists. If you download that, there's a pile of stuff there that gets you onto, gives you the addresses of all kinds of mailing lists. There's also, it's an American book, but there's a lot of the stuff in here, The Lawyer's Guide to the Internet. This is a publication of the American Bar Association by a guy named Burgess Allison, who writes a regular column on computer subjects for the ABA Journal. And I think it's a very good book. You'll see as well I bookmarked a bunch of law-related addresses. And some of them are bizarre, really bizarre, like the Electric Law Library's Legal Professionals Lounge, you know, stuff like that. Or the Legal Network for Everyone. There's a lot of access through the first two that I've listed, Government of Canada homepage and the Osgoode Hall Law School, and through Canadian Legal Resources. The last one on that page, Washburn University School of Law, is way up front in internet services for lawyers. They run quite a few of the mailing lists. In fact, on page C11, you'll see 3 mailing lists that I happen to be involved with. Listserv is just the general address. Family law, there's a family law list out of WU, Washburn University, and Net Lawyers, also out of Washburn University. If you're doing these things, I urge you get the digest on mailing lists. In fact, I think that's generally not bad advice, because otherwise you get 30 individual email messages every day. It's better to get a digest. You download the one piece that comes in, you scan the contents, and then you delete everything you don't want. The news and reports on C10, I think that's self-explanatory. There's a whole lot of stuff out there. There's just tons of public or news information, and it's far too much to stay with on a daily basis. InfoRamp, which is the server I use, has a very good homepage with a bunch of news and information connections. It's very, very useful. The third one there, you see it says ET. It's not ET. Okay, we're not calling home for ET. That's the Electronic Telegraph, the London Daily Telegraph, and that's a very good list. Frank Magazine's on there. That's the last one I listed. It's pretty useless. So that is experience up to that point. Now, I use the web as well for a lot of personal stuff, of course, personal research. There's a lot of personal email as well that I do. But just as one example that, as I say, may be behind the kind of things you're doing, but it worked for me. We had a case that involved an autistic child. The child had something called Asperger's syndrome. Asperger's syndrome is kind of high-level autism, and I wanted to know more about it. So I dialed up open text and put in the phrase Asperger's syndrome. Bang! Out came a pile of information, amazingly enough, including a parents group of children who had Asperger's syndrome, an FAQ on Asperger's, and all kinds of information. So in about 20 minutes or half an hour, I had downloaded and saved certain files. I had as much information about this as I would ever need for the case. It's cost effective, of course, because I didn't have to get expensive medical reports. I didn't have to spend hours roaming around in a medical library. I got just what I wanted, and it took no more than half an hour. So this is the kind of function that for me is the web at its most useful. And of course you can translate that experience to all kinds of personal stuff. I've researched a lot of other things that I'm interested in, non-law related topics on there, and it's very, very good for that. There is something for everyone out there. Any subject you're interested in, it's out there. And using open text or one of the other good search engines, you're going to find it. I wanted to share with you one letter that I got, because this is somebody else's experience. I got a very nice letter from a lawyer named Bill Wilkins, who practices in Hamilton. I'll read you just part of it, if I may. He talks about how he was forced to get involved in this stuff because of the exigencies of his practice. He says, "I recently made the expansion to the internet and intercomputer access. I was forced into that move by the fact that my secretary commenced her second maternity leave. Rather than lose her entirely, she suggested that we gear up our respective computers so that she could work for me from home on an hourly basis. The ability to do so means that I do not have to hire any additional staff person to replace her. It promises a real net dollar gain for both of us. It was approximately 1 week ago my skills advanced to the point where I was able to become connected to the internet. After wasting several days window shopping at various aspects of the internet, I started to explore the aspect of connection to various law libraries. I immediately became connected with and placed bookmarks for the University of Western Ontario Library, Queen's University, and York University Osgoode Hall homepages. Within moments, I discovered the Ontario Family Law Bulletin and immediately ran copies of the bulletins available. For several years, I've acted for a client in Germany who has a Hague Convention problem that has festered for quite some time. I was thrilled to be able to obtain from your Family Law Bulletin the latest up-to-date information on the court's approach to Hague Convention problems. All in, of course, a thumbnail sketch which still provided me with many current cases." And it goes on to say thanks for that. So it's nice. There isn't a lot of this that comes back. So it's nice that somebody can use it, make practical use of it, and that it's helpful. And maybe when he's out of his depth, he'll refer the case to me.
Malcolm,
Yes.
I wonder if you could address the issue of the viability of paid subscription publication.
We thought about that. We thought if we start up this bulletin, maybe we'll say, if you want to consult with us, if you got questions that you want answered, we'll respond to your questions, but you got to pay us X dollars a year and get a password or something like that. I was very bothered by the ethical side of that. I thought it might be regarded as some kind of steering, and it just didn't appeal.
How about just paid subscription, that you're entitled to the Family Law Bulletin and 26 issues a year at X amount?
Well, if they want to subscribe to the print bulletin, they can do it, and we do try to correlate these things. It's not, I guess, manifest on the material here, but there are often references within the electronic bulletin. Oh, here's one, page C3, where Jeff Wilson, writing about the Hague Convention, refers to some print material. It's actually a book that he wrote called On Children and the Law, but sometimes we'll tell people there's more about this in the print Ontario Family Law Reporter, and you can subscribe to that. I don't think I'm interested in doing this thing in any sense commercially.
Is there any effect on the paid subscription or the purchasing of the hard copy, since people can get it free on the net?
It's not the same thing. It's not the same thing as the print copy, and I think that the marketing of the print Ontario Family Law Reporter by Wonderworths is so appalling that it won't make any difference what we do.
Okay, one other thing before I throw this open. A number of people, a number of law firms are looking at publication on the web as a way of distributing their newsletter or creating a newsletter and distributing. Do you have any comments on that?
Well, they do it. Our firm does it. We got our homepage, and a lot of other firms do. I'm not convinced that it has any value at all, other than feeding ego. I just don't see it.
A firm newsletter?
Well, as a public service, okay. But if you're talking about this as a marketing device, as having some commercial value to the firm, I don't see it. I just don't see it.
Would you say that's the same in an international practice, where accessibility to directories within Canada might not be as readily available to, for example, European firms?
Well, there are directories. There are directories. In fact, one of them's coming out very soon. It's still under construction, but it's a very ambitious undertaking called Lexpert. I put their homepage in my material, and Lexpert is sort of a catalogue raisonné of lawyers in many, many different practice areas across Canada with comments about the individual lawyers. It's supposed to be a qualitative guide and survey to lawyers in Canada.
Comments about the lawyers?
Yeah.
Who made the comments?
I think it was invited from colleagues. Yes. Yeah. I mean, there are other such directions. For example, in the States there's something called Best Lawyers in America. I'm not sure if it's on the internet. But the point you're making is a good one. I think maybe just by being out there, somebody in Sweden will see you and may think, oh, well, there's somebody who apparently knows something about this subject. I'll get in touch with that person.
Well, for example, when I was looking up a point on trademark law in the UK,
yeah,
two firms kept coming up over and over again. If I didn't have connections in the UK, I would have been inclined to use one or the other of them for the particular problem that I had.
Okay. Well, a lot of lawyers and law firms do that. If you get the general lawyers mailing list that I've put here, the one out of Washburn University, it's full of that kind of stuff about people who are clearly trying to establish that they have some credentials or expertise in a practice area. They're casting their bread on the waters, you know. And I think that's what this thing is. You obviously have no control. You have no idea of the quality of response to this thing. Sometimes you know the number of responses. And I know how many people have hit our bulletin on CompuServe, but so what? It's just a number.
Just a suggestion. I noticed in the list of search engines now, you have mentioned something that I happened on that I now be aware of. That is search engine gatherer, starting point.
Gatherer.
Well,
is that the name of it?
No, it's called Starting Point.
Oh, Starting Point.
Okay. The address is www.stt.com. What it does is it gathers links to all the large search engines that are out there, from web crawler to Yahoo to Alta Vista. Open text is in there as well. And the beauty of it is that you can enter your search term once in starting point, and then link to the search engine that you first want to look at. That search engine will start off and turn up some sites or whatever. And then you can come back to that either by opening a new window, if that's your home page, and just link to the next search engine. So that you can do a real research project, because some search engines will find things that others won't.
You're absolutely right. In fact, there's another two such search engine compilers that I bookmarked last week after this thing had come out, and I'm sorry, I just won't recall the names, but they have the same function that you're talking about, and I haven't even tried them yet.
The starting point is very good. Can we get the site again?
Yes, sir. www.stpt.com. I think I became aware of it through either one of the two services. There's wired or hot wired on that.
Oh, yeah.
Electronic version of Wired magazine.
Oh, yeah.
And the other is CNET, C Pipeline Net. I'm not sure how
I'm not sure.
note that.
Oh, yes.
The site span W's at one end, com at the other, and throw wired as part of the address, and you'll find that. And the beauty of these two sites is that there are weekly, if you subscribe to their weekly list, they will give you new sites, new thoughts, new ideas.
Yeah, that's the hot wired address. Yeah, I left that off. I do have that one as well mentioned. So that one was, your gatherer was www.stpt.com. Thank you very much. Okay.
If I can throw a differing viewpoint from a little bit, as a consumer of information rather than a producer of one on the net, I have come to the point where I can't keep up with all these mailing lists and announcements and things that are going on, and what I'm trying to do is pare down my mailing lists to the ones which I think carry most meat, the highest signal to noise ratio. I don't know if I could, I probably would say that if I were interested in that area of law, that yours is the list that I would want. I don't know if I would extend that to say, well, then you're going to get my business. What's the threshold level here? You put publications out too, that don't necessarily, you put hard copy publications out that don't necessarily result in direct business. What's the threshold level if you wanted to have a presence? At what point will you decide this is not useful for you anymore to keep the bulletin up?
When I get bored with it, I suppose. But I said before, it's so little effort for me to do it, and it's kind of fun, put the thing together. I create it on WordPerfect and save it in DOS, and just attach it as a document. Huh? That's all there is to it. So it doesn't take a lot of time, and yeah, I'm sure that sooner or later I'll decide to hell with it. But it'll go for a while yet. Hey, John. John, I can't hear you. I'm sorry.
Your firm has a very nice website. What sort of experience have you had in terms of payback on the website? It's fairly recent.
Our law firm homepage?
Yeah.
None that I'm aware of. And did you find that our homepage worked right?
Yeah.
Were the links okay?
Yeah, it seemed to. I
What?
had trouble with Facebook feeds.
Good. Because for a while I thought that the links on our homepage weren't working properly, and I'm glad that you found they are. Fine.
Drop your browser.
Well, I was past it at that point. I'd solved that problem. Thanks very much. Okay. Thank you. Thanks for your attention.
Thank you, Malcolm. We're going to turn to the topic I called most convoluted now. I have to tell you that my graphic designer that I mentioned to earlier called me up about a week and a half ago to say that he had been browsing the internet and ran across a site in Vancouver which used some wonderful graphics, his. They hadn't actually asked for them. He sent them a note asking them to give them back and not use them, and they sent him back a note saying, "Heh."
That doesn't come as any surprise to me at all, and I found it a little humorous when a couple of weeks ago I pulled an article out of the Toronto Star, which is a reprint of a Washington Post article that says in bold letters here, "Copyright law applies to internet, judge rules." And that was sort of funny to me because I thought, of course, why wouldn't it? Copyright applies to any work. But it didn't take long to realize that this is actually going to come as quite a shock to many people. And I don't think that it's ignorance of copyright law that causes that problem. It's really ignorance of what the internet is all about. There is certainly a lot of ignorance about copyright law. I know that lawyers tend to have familiarity with the fundamentals of copyright, and I'm going to get into a few of them very briefly, just to make sure we all appreciate what the technical issues are here. I'm not going to say anything today, incidentally, on patents or designs, because there's very little to be said in terms of patents and designs as they relate to the internet. It might be a useful search tool one day. Right now it's not. The most relevant patents and designs for determining whether your new invention is novel are still found at patent offices and design offices around the world, and that's going to remain for some time. Confidential information and trade secrets, there isn't anything that I could say that Michael hasn't already touched on. If you're not going to heed his advice regarding safeguards, keep them away from the internet. If you want them to remain confidential, they have no business being anywhere near the World Wide Web. So primarily I'm going to focus on copyright and trademark. As most of you know, as I just mentioned, copyright applies to any work which is original to its creator. There are about 3 prerequisites. Originality, in the sense that is the creation of the author. It doesn't have to be new, it can be identical to something that came before, as long as it is the product of the author's own creation. His or her labor and efforts went into it. The work must be fixed in a material form, and this is going to raise one of the big issues on the internet, because when you're talking about ones and zeros and electrons zipping around circuits, when something is fixed in form, gets to be a little bit of a problem. And in the materials I've read in preparation for today, I've seen some widely divergent views on that. The third prerequisite to copyright arising in Canada is two-parter. Either the author is, and I'm going to take the words basically from the Act, you're going to see in a moment exactly how long ago the Copyright Act was enacted. The author was a British subject, a resident within Her Majesty's realms and territories, or a citizen, subject of, or ordinarily resident in a Berne Convention country. And for those of you who aren't aware of what the Berne Convention is, it's an international intellectual property convention of which Canada is an adherent. There are some scores of adherents, and it sets out the fundamentals that each adherent must apply in their domestic copyright law. If you are an author that falls into one of those territories, and you create an original work that is fixed in form, copyright will arise in it. But additionally, if you are not a resident, subject, or citizen of one of these territories, copyright will arise in your work if it is first published in one of those territories. And this is the second big problem that the internet raises, because where a work is published is a very difficult thing to establish. Somebody in a non-convention country, Tajikistan, we'll say, posts copyrighted work on the net, and it immediately becomes available to every country around the world. Can it be said to have been published in those countries? And if the answer to that is yes, then instantly all of these non-convention adherents have a way of obtaining automatically copyright protection in all of the convention countries. The first misconception that most of your clients will have, you'll find, is that you have to copyright something. Copyright is something that arises automatically, and when somebody asks me, how do I copyright this? The answer is, well, you don't have to. It just happened when you created it, as long as it's original and it's fixed in a material form. There are 4 basic types of works that we're talking about, and I'll give examples of how they apply to the internet. The basic works are literary, dramatic, musical, and artistic works, and what those are will be fairly obvious in some cases. An article that appears on a back page of your homepage is obviously a literary work. A drawing is obviously an artistic work. Photographs are artistic works. Some which are a little less obvious, computer programs, which are defined as literary works, and both the source code and the object code are protected as literary works. One of my favorites, cinematographs, which is defined as anything produced by a process analogous to cinematography. Don't ask me what that means. I've never seen a judge decide. But it is generally taken as including movies, cartoons, motion pictures, what we would loosely describe as motion pictures. That is a dramatic work. And for those of you who use Netscape as a browser, you'll notice that little N logo up in the upper right-hand corner of your screen with the shooting stars that go across it. Very short sequence, very simple, but in fact it is a cinematograph. And it is protected as a dramatic work under the Copyright Act.
Plot's a little weak, but sure.
That's right. There are offshoots to these as well that you have to be aware of. One of them is a compilation. A compilation can be one of two things, either a selection or arrangement of literary, dramatic, musical, and artistic works. For example, a book with pictures and text. That would be a compilation. The underlying works are the literary work in the text and the artistic work in the pictures, and their copyright is not affected by the fact that there is a compilation of the two works, but copyright also arises in the compilation. And you're going to see this gets very complicated when you start creating web pages that have moving graphics and text and maybe a little music in the background, and all together it's protected as a compilation. And you have to think about who owns what and who has to be remunerated and what licenses do you need, and it really can be a dog's breakfast. Another type of compilation is a selection or arrangement of data. And this can be any kind of data. For example, the list of links that Malcolm provided in his written materials is a selection and arrangement of data. And it's protected because of the labor, the effort that he went through to create that list. And I'm going to mention here the first of many points that differ from US law. Copyright in Canada is based on what we call the sweat and brow doctrine. You put in the effort, you deserve the protection. In the United States, it's a little bit different. A mere list of names in a telephone directory is not protected under copyright in the United States. There's not sufficient originality in the United States. But in Canada, the fact that you compiled that list gives you copyright protection. So for example, I can create a map of Kapuskasing. And I will have to get up in a plane and take an aerial photograph, and I'll have to drive around and get all the street names and do all that myself. I cannot just copy somebody else's map. And even though my map will end up being identical to the first creator's map, that's okay. It's my own original creation. I didn't copy from him, so I don't infringe, but I have to go through all that on my own. And you've noticed at a couple of points in today's discussions, people were talking about browsing the web and finding web pages that you like and taking pieces of them. To some degree, that's okay. And the reason is that copyright doesn't protect ideas or concepts. It only protects the way an idea or concept is actually expressed. Anyone could have painted a picture of the Mona Lisa, but the particular picture that we all know, the famous one, you cannot just, well, you can copy it because the author's been dead for more than 50 years. Take something a little more current. The case would be the idea is open to everybody to use, but the actual expression of that idea by an author, by an artist, by a musical composer is not. And there's a very fine line here that you have to be aware of. So when you go browsing around the net and find things that you like, look at formats, look at ideas, what is included in the web page. That's all fine and good. Take lots of notes, but don't copy the source code and don't copy the graphics, because these things are expressions of an idea which are protected by copyright. Now that you know what copyright exists in, you have to know basically what rights that gives the author. And this is an area that really people know very little about. Copyright is entirely statutory. There is no such thing as common law in copyright. And the rights that are granted to a copyright owner are set out in Section 3 of the Copyright Act. There are quite a number of them. I don't propose to go into many of them. I'm only going to touch on the ones that are relevant to today's discussion. The big right has always been the right to produce or reproduce a work. Certainly with movies on video, with printed works and so on, this is the copyright owner's best protection. And this means the right to reproduce the work or any substantial part of the work in a material form. Now we get back to those words material form again, and we're going to talk about browsing in a minute. You're going to see what kind of problem that raises on the internet. But that means any reproduction of any substantial part in a material form. So when somebody says to you, what do you mean I can't tape last night's hockey game and watch it today? It's just for my private use. There's no law against that. Well, there is. And this is another distinction from the United States, which I'll get to when we talk about exemptions. The US is a little bit freer about what types of uses you can make legitimately with a work than Canada is. And the reason I'm going to draw these contrasts with the US is most of the stuff you'll find on the internet is based in the United States. And if you go by what you read in FAQs and information resources on copyright, you're likely to be misled in a number of different areas. You've got to look at where that material originates. If it's from the United States, it's not quite on the money. Fundamentally, their copyright law is very similar to ours, but there's some very important distinctions. So the right to produce or reproduce the work is the obvious one. We all know about that. You have every right to use a work. For example, this article that I clipped out of the newspaper, I can post that onto a nice piece of walnut and sell it as a plaque. And nobody can say anything about that. But I can't photocopy it because that would be a reproduction. You cannot make a reproduction. Another important work for purposes of the internet is the right to publish. The copyright owner has the right to publish the work first, to be the first one to disclose or let the work out into the market. And this is important in terms of email. And in fact, this case that I drew to your attention, copyright law applies to the internet, this is a US case. It's been going on for some time. You'll see all sorts of comments zipping around the net. It relates to the Church of Scientology, where an ex-member of the church decided to dump onto the net holy scriptures that were being made available only to church members that had achieved a certain level or given up a certain number of their worldly possessions or whatever it was. The judge found that that violates the right to publish. Those scriptures were unpublished because they were available to a private audience until this guy came along, and instantly they were available to everybody. The right to communicate the work to the public by telecommunication, which has only recently come of age, primarily brought on by cable rebroadcasters. There was a whole slew of laws that came into effect in the late 1980s that recognized the problems that copyright was encountering with broadcasters. But in the context of the internet, it seems that this would probably be ultimately the most important right a copyright owner has. If I purchase a digitized photograph, as I said, I'm entitled to use it any way I want, as long as I don't make a reproduction of it. So if I place my one copy of this digitized photograph on my web page, I'm not making a reproduction that would violate the act. However, I'm communicating that work by telecommunication to anybody who visits my web page. So there is a restriction there above and beyond making a reproduction of the work. The right to authorize any act which is reserved to the copyright owner is itself an infringement of copyright, and I'm going to talk about links in a moment, where we're going to see this gets a little bit tricky. Briefly, I'm going to mention moral rights. It's something that most people don't know about. They're very strong in Canada, much stronger than elsewhere. Moral rights belong to the author, regardless of who owns the work. The author retains the right to the integrity of the work, the right to prevent distortions or mutilations in the work that would dishonor his or her reputation, the right to be associated with the work. And these rights can be waived, but they cannot be assigned. An infringement of moral rights is subject to the same remedies as infringement of any other right. The ease with which things can be modified once they've been digitized can make this fairly important. Now, I've already mentioned that you can only infringe one of these rights by copying or communicating an actual work or something of that nature. You can arrive at something, a song, for example, that is exactly like a song that was released in the 1980s. Nobody may listen to it, but say that you do. It is not an infringement of copyright if you arrived at it independently. Okay? The problem is that courts have traditionally used a twofold test in determining whether something is in fact an infringement. Number one, how similar is it to the other work? And number two, did the alleged infringer have access to the other work? Well, the internet pretty well wipes out the second part of that test. Anything that's on the internet is accessible to everybody. So the question of similarity now in determining whether something is an infringement is going to become very important. The internet raises these issues first because of the digitization, as I mentioned a moment ago, of works. Particularly in the case of things like photographs, where if you wanted to digitize a photograph, you would require equipment that costs thousands of dollars. But for no money at all, other than the monthly fee you're paying your access provider, you have access to tens of thousands, perhaps hundreds of thousands of digitized photographs on the internet. And once you've got them, you can send them anywhere you want. You can modify them using relatively cheap software. The ease with which all this can happen has become a real problem, similar to the advent of videotaping. All of a sudden, or even audio taping in the case of record producers and videotaping for movie producers, the ease with which now somebody can make a reproduction of these things and the difficulty in enforcing copyright because it's virtually risk-free, let's face it. Most people in this room, I would venture to say, has videotaped something even for time-shifting purposes. Presents a very interesting challenge, shall we say, for people putting works on the net. This was always a problem with the internet, but for a long time, the internet was reserved to basically an academic faction. Now with businesses and entertainment type media coming onto the internet, they're a little more protective of their works. They don't like this idea that it's accessible to everybody and people will freely copy it at will. And they're starting to raise a bit of a fuss about this, and rightly so. A lot of the things I'm going to talk about today are still in the very academic stage, you'll recognize. But I'm going to try and give you some practical pointers on how to avoid infringement and how to protect your own works when you ultimately do get them on the internet. The intangibility of digital signals presents the problem that it is very difficult to determine when something is produced in a material form. You'll recall first that that's a prerequisite to copyright arising to begin with, and second, it's a prerequisite to infringing copyright by making a reproduction. And one of the big debates going on today is, when you browse somebody's website, are you making a material reproduction of the materials that are stored there? This is a very important question, because if you are, then you are infringing copyright just by going to the website. The Information Highway Advisory Council Copyright Subcommittee said, yes, that is a material reproduction, even if it's temporarily stored in RAM in your computer and visible to you on the screen until you move on to something else. They're the only ones that I know of that have come to that conclusion. I disagree with it, and I noted that the Information Highway Advisory Council itself did not adopt that conclusion. I think that it's pretty clear that hard copy, printed, or downloading onto your hard drive, those are material reproductions. But merely browsing, and this is the position I'm going to take today, is not a material reproduction of a work and does not infringe copyright. Well, one of the problems that arises all of a sudden is that many of the popular browsers that we use, including Netscape and McWeb, which I happen to favor, cache the web page to your hard drive as soon as you visit it. You've got literally a disk cache from your browser. The browser has made you infringe copyright by creating a material copy of the page that you're visiting. And there's not an awful lot you can do about that. Actually, I think it's a wonderful thing. I think that to be able to travel backwards and forwards through your search path is very useful. It saves a lot of time online, and the net is getting very crowded from a traffic viewpoint. But in fact, technically, it is an infringement of copyright.
You can turn off the cache.
Can you turn off the cache?
You can turn off the cache.
You can turn off the cache in Netscape.
Can you?
I don't think that I would do that.
Yeah.
I don't think that I would do that simply because it would make searches much, much more protracted while you have to wait for everything to be downloaded onto your computer again, figure out where you're going and coming from.
Those people who are interested in how they can not infringe copyright if you're using Netscape.
For those who are interested, Louis will explain.
You go into your preferences and there's something under cache which says, always check, never check, check once a day. Okay, that's where it says when you go back to some place you visited, If you choose never check, in fact, it always looks on your disk first before it goes out. If you choose always check, it always goes out to the new site. If you choose once a day, it only checks on that day and then doesn't check for the rest of your session.
How does it keep that from caching, though? How does it keep it from caching?
When you say always check, it means it doesn't hold it on your disk. It shouldn't hold it on your disk. And you set your cache amount to 0, and every time you hit to go to that site, it will go out and always check to see what's on that site.
I don't know that you can do that in McWeb, and I think if I set the cache to 0, I'll crash my computer every time, because there seem to be about 2,000 things I can do to crash.
Suffer the consequences.
Yes.
Not to interrupt your flow of thought, but just so that I understand it, are you basically saying that these browsers are sort of the modern day equivalent of standing in an art gallery and looking at a work? That although the mechanics may involve some temporary reproduction on your machine, what actually is going on is you're just looking, you're literally standing there looking at a page.
I think I'd draw that analogy to if the intention of the individual is simply to look at the web page, but I think it's more analogous to standing in an art gallery looking at a painting with a camera constantly attached to your tie, constantly clicking pictures as you go along. You are actually making reproductions, perhaps without realizing it, and I think a lot of people don't realize it. One of the things that I suggested in my paper is that after every search, clear your browser cache. Just get all the stuff off of your hard drive. We'll get into the exemptions such as fair dealing, and it's entirely possible that this is fair dealing with the work because of the way it facilitates your use of the website. But it's strictly speaking an infringement, more so than just viewing. No. Netscape will continue to accumulate cached documents. I don't know if Netscape is smart enough to look in your disk cache first before it goes out to the actual site. If it's not, then yes.
Yes,
I'm pretty sure it's multiple copies.
if you choose never check, which is never check the original
Then it will
site,
go to-
then it keeps track of what it actually has on your disk.
Yes.
Clear. There's a button that says clear disk cache now. There's a button right on the cache thing.
That's Netscape F.
That's any Netscape, but you have to click the button, and you would only do it at the end of your session before you left if you were concerned about leaving the things on your disk. While you're a session in progress, while you're actually on, you've hit a page, you jump forward, you click back. Whether or not it's in memory or cached to disk at that moment depends on your computer and how it handles memory and whether virtual memory is set.
Really neat issue, but what's the practical implication of it? I mean, I don't expect the net police to show up at my house tomorrow to check to see whether Netscape has cached something from a web page I visited, particularly when the publisher is putting it there for the world to see.
True, but would you say the same thing about downloading the document onto your hard drive and reading it 2 days later? The Netscape police still won't.
But I would
right.
an implied
And
license
practically,
that I'm putting it out there for public consumption,
okay.
And it's going to, I mean, it's in electronic form. I expect it's going to be used.
I agree with you in terms of the disk cache, and we'll get to that in a moment, because implied license right now seems to me a very important potential exemption here. Of course, until a judge decides that it exists only notionally. But I do agree with you that that's going to be the case. Okay. I'm going to have to just briefly cover a few topics, and do interrupt me as we go along here. I don't mind at all having the train of thought derailed a bit, but I do want to get through the most important points. The one that I mentioned about publication, where a work is published when it's placed on the net, this is going to be a very key issue in some cases. The Copyright Act, in its definition of publication, specifically excludes communicating the work to the public by telecommunication. That does not count as a publication. But on the other hand, it specifically includes making copies of the work available to the public. And the neat thing about the internet is you do both at the same time. Okay? This may be another relevance of this disk cache that's created as you're using your browser. So if you happen to live in one of these non-protected countries, there's a good argument here that you're protected in all of the Berne Convention countries under copyright, the same as any resident or national of those countries, as soon as you put your work on the internet. It's cheating, but I think that it will work in the end. I want to talk momentarily about linking too, because as I mentioned, to authorize something that is an infringement of copyright is itself an infringement of copyright and subject to all the same remedies as the guy who actually infringes. And questions have been raised, well, what about when you put a link to somebody else's site? Are you then infringing copyright? The best answer, infringing by authorizing, and the best answer that I could come up with is no, you're not. Because the mere act of putting a pathway or a gateway to that other site does not result in a production or reproduction of that work, in the telecommunication of that work to the actual user, and so on. If those acts, the actual browsing of that, as I said, my premise is that is not an infringement. If that's the only thing that the user who clicks on your link does, that's all ostensibly you're authorizing him to do, you are not authorizing an infringement of copyright.
May I ask a general question here?
Sure.
I think it's probably following the line of the gentleman. Some browsers work when you set up a link where all the browser does is send your computer the address of the link that it's pointing you to, and your computer goes out and follows that address. Sometimes the link actually takes you there, maybe funnels you through, you're going through that computer. Should it really matter what the basis of the technology is when trying to sort out this end of the law?
No, it shouldn't at all, and the law is going to have to be adapted either legislatively or judicially to accommodate the various types of technology that are out there. The route that is taken to the ultimate address makes it a little difficult to determine who's using the work, and if the copyright owner is looking for compensation, well, who do they look to? They have to follow this convoluted path from site to site. But that's a practical problem. I think that the link itself is going to have to be taken ultimately as not authorizing anything, regardless what your software does, either direct to the site, or as Malcolm did, he could set out a list of links in his paper, and that's effectively the same thing. You're showing people the way. I can walk you into a library and point at a magazine and say, take a look at the article at page 33, right? That is effectively a link. I'm pointing you to the direction. I have no control over the provision of that article to the public, and if the person at the linked website doesn't want that article to be made available, they shouldn't have it at the website. Handing you a piece of paper with the link, with the URL written on it, is effectively the same as putting that link on my site, with one exception, and that is that under the definitions in the Copyright Act, work includes the title, where the title of the work is original and distinctive. If your link is the title of the work, and that title is original and distinctive, the link itself may infringe copyright. It's a very minor point, but
on my website, I don't have it, somebody's website, and I say a very interesting site is the law guide, which is the name that Rod's firm uses. That's different from saying, see Rod McKeown's law site, or a very interesting site is found at this URL. If I put in the name that they have, am I infringing, or is it permissible for me to say, you might find the law guide very interesting BBS, and click here to go there?
I think it's perfectly permissible for you to say that, as long as you're not saying anything that's disparaging. You're entitled to do that.
Well, if you said, here's my collection of the 10 most boring sites I've ever seen on the internet, and you have a list of 10 links, and it's not just the name of the site, but it actually links you out there. Do they own?
There is. There's
Yeah. Do they have the right to have you take it off?
I'm not a libel lawyer. So
No.
I
Assuming
don't know.
assuming that libel
From
isn't
a
the
purely
issue.
copyright viewpoint, they have no right to prevent you from doing
From
that.
using the link.
Comment when he said, he's left on his committee, he said that he was approached by York, who asked for permission to put his bulletin onto their site.
To link to his site, you're
No.
saying? Or to actually put the bulletin on?
No, actually, and this is we should have elaborated on this, but Malcolm was approached by another site that said, we like what you've done, we'd like to incorporate it in our site. If someone merely wanted to link to your site, it is considered a net courtesy, but not a requirement, to ask them, do you mind if I link? But certainly there are all kinds of people who are going to link to your site, who have pointers that aren't going to ask you. In Malcolm's case, they asked if they could take his material, and they've actually reproduced it in a different form because they have it hyperlinked. His was just straight text, where they've done graphics and interesting things with it. So in fact, they probably didn't have to ask him in any case, but as a courtesy. They've asked him and they like to use his name and they want him to keep up the content. So, but in Malcolm's case in particular, there is a different substance from what he had to what it is they've done with it.
Well, let me describe one situation. Oh, yes. They're in the process of addressing this issue, but the problem is that copyright ownership on the net involves so many different types of work from so many different sources, it's an administrative nightmare. And I really think that there's no easy solution to this. No, I agree, and I think that the collectives will, in fact, get their head around it eventually.
They are, in fact. SOCAN and CAN copy. SOCAN is the musical collective. CAN copy is the photocopying. Are both in the process now of developing tariffs for internet and internet-type communications, and so SOCAN's tariffs are currently in public hearings. And a number of people have raised objections to them. Their proposed tariff perhaps is so high that it would effectively take make it impossible to sample and distribute music over the internet. But I mean, these are questions of economics and not questions of can it be done. The answer is it is being done.
But there's a threshold issue here.
Well, SOCAN wants to charge by subscriber, not by hit. But that, again, it's a technicality. It's a technical issue of measuring the usage, which has always been the problem, and it's the problem that CAN copy has with photocopying in libraries. It's just a question of measuring and allocating. And personal opinion, those problems will be resolved through more effective metering, and then that'll be the end of it.
The difficulty right now is somebody's first going to have to decide how far do you have to go before it's a copyright infringement. If browsing is not an infringement of copyright, and I say if because it's up for grabs, then only when you actually download or print a document, when you reproduce it or transmit it to another site, are you infringing. How does the site from which you're getting that information or that software or whatever it is know what you've done with it? Okay, this is a real problem. If you're going to make browsing an infringement, you cover all bases. Once your site hits their site, once your computer hits their site, you're subject to paying some kind of royalty, but of course you could be there by accident. I use a program called uRoulette, which is available somewhere on the net out there, which you spin the roulette wheel and it just tosses you off to a random URL anywhere around the world. It's a very interesting thing when you're just finishing off your 3 hours of searching, just to sort of let your mind relax a little bit. But the fact of the matter is, I would hate to arrive at something like the Botswana Wrestling College homepage and have to pay just for the fact that it came up on my screen.
Yeah, Mark, some of the old issues, at least in my opinion, still haven't been sorted out. Who owns judicial reports? The tariff that they tried to slap on blank audio tape. I mean, these are all things that have been around for a long time and in my opinion still aren't solved.
The problem there, of course, is political one. For those people who who have an access provider because they only use email, they're paying royalties for all sorts of things that other people are taking advantage of. It's like paying taxes to keep the roads up when you're not a driver.
Or local telephone usage subsidized.
There are, yeah.
Yes, I think the only technical difference, if I may, is that in the, say, the world of cable or the world of telephone, we have a clear difference between provider and consumer, whereas in the internet, you could be both. I mean, it's just a continual line, and that's a little tougher.
What about this reply of implied license? The minute you decide to interact on the internet, you put something on there. Isn't there an implied license that would counter all of these?
There is a question of that. It would have to be fairly clear circumstances. And I'll give you an example of what clearly is covered by an implied license. You go and you buy software from your local software store, and the software doesn't come with a software agreement, if you can believe that that still happens today. You have to make a reproduction of that software in order to use it. You have to actually either load it on your hard drive or at the very least make a backup copy or something of this nature. These are things, the loading of that software on your hard drive to use the product will be an implied license granted to you by the owner of copyright in the software, because it's called derogation from grant. You can't give with the right hand and take away with the left at the same time. You can't sell somebody something that they can't use. How far that goes on the internet is a very difficult question. It's going to depend a lot on what people understand when they put materials on the internet. And that's a hard question to answer. That's changing rapidly. That's changing by the week. There was a very recent case of a photographer, in fact, just decided in Ontario in December, who had taken a photograph that was used for a magazine cover. Well, the magazine decided to rerun that cover some years later. And the photographer successfully sued for infringing copyright by establishing that conventions in that industry were, absent an agreement to the contrary, the photographer retains copyright and licenses a one-time use. The second use was an infringement of copyright. How you're going to determine what the conventions are on the internet is going to be a little more difficult. It's going to be up to the judge in the case that comes along. And it changes every week, that's right. I think you can assume for the moment no implied license will extend to making a hard copy of a work that's protected by copyright, to downloading it onto your hard drive deliberately. I don't think you can assume there's an implied license to that. Certainly, it's fair to assume for now that you have an implied license to browse, if indeed that would be an infringement at all. No implied license will extend to your doing anything with a work that was not authorized by the copyright owner. For example, these Scientology scriptures that are on there. There's nothing you can do with that because they weren't initially authorized. And no implied license will extend beyond the terms that the copyright owner expressly imposes when you reach their website. For example, one of the ideas I have for a website, for a business that promotes itself, many people won't care if you're promoting your business on the internet. You're happy to have people copying certain materials. It's like free distribution of your brochure. So what you do is you allow people to make copies, providing they copy the entire thing, including your masthead, including your copyright notice, etc. You can put any restrictions you want on the use of the work beyond browsing. And I think that's something that people have to consider very carefully in their own web pages. What restrictions do they want to put on users? And when you decide what restrictions, set them out very clearly. Most people, when you say all rights reserved, most people have no idea what that means. What rights are reserved here? So they probably know they can't make a physical copy of it, but that's about all. And I think that one of the big problems on the internet right now is the lack of education of this enormous and growing faction of users that are not academic. They simply have no idea what copyright is all about and what you can and can't do with copyrighted works.
This is a question that relates more to the copyright issue and the earlier liability and culpability issue. What's the significance of the note you sometimes see at the bottom of the home page, down the very bottom where there's a whole bunch of links that says legal stuff, legal notes. You sometimes see that right on it. If you go to that, that is generally a copyright message. What happens if that's the only place where you put your culpability or we strongly recommend that this is only for general information and that under no circumstances should you rely on this only contact lawyer. The only way
Yeah, and in this world of links, I think that's a dangerous thing because somebody is liable to link to your site somewhere behind your homepage where that particular option is not available to them. They will not look at those terms and conditions on every page.
You don't have to put the sentence in.
Well, depending on how long the sentence is, if you're simply saying all rights reserved, you may not copy, transmit, publish, whatever, without consent, you should put that on every page. But if you're talking about a whole paragraph of restrictions and permissions and this sort of thing, then just put a link on every page to that.
If I can jump in for a sec, from an HTML coding point of view, you can use what's called the include command, where you can simply include a text file. So the text file would exist only once in your list of files, and you can simply include that message at the bottom of every page with a one-line command, as opposed to, pardon me? Yes, yes,
Right.
That's right. Yeah, it automatically appears at the bottom of every page, as opposed to the link, which, as you point out, isn't the best way to do it.
And one thing that I am going to suggest here in terms of authorizing infringement is if you do give certain permissions under copyright to people to use works on your web page in a certain way, then make sure you separate your links from links to other sites so people don't mistakenly believe when they link up to another site that they're going by your rules. Okay? That could be authorizing an infringement. If you specifically say, going to any of the following links, you are allowed to make a copy for personal use, and it turns out one of those links doesn't belong to your website, that would be a problem. Okay, so I recommend that you keep your own links separate from links to other websites, and I've seen actually people go as far as to say, the following links are not connected to our site, so you're going to have to look to the owners of those sites for what you can and cannot do with their works.
Just have a couple minutes.
Yeah, we're not going to get to talk about trademarks. I'm going to recommend that you read the paper. There are a couple of interesting points that are raised there, quite detailed in terms of trademarks, and I'm not going to get into them now, but there's many, many more points and materials that we didn't get a chance to canvass today. I tried to basically follow up on some of the things that had been discussed earlier and put the intellectual property aspects of that into perspective here. But do read the paper. I think that you'll find a lot of good ideas, particularly, for example, one that I will mention briefly, protecting your own web materials. If you contract somebody to do your web page, recognize, and this is a very poorly known point, that unless they are your employee, they own copyright. You have to actually have an agreement that assigns in writing copyright to you. Otherwise, the person that you get to do your web page will retain copyright in the web page. So number one, you want to make sure you get that. You may want to use that web page for other purposes. You don't want to find out later that you only had an implied license. You're not allowed to make any modifications because the author didn't waive his moral rights, and so on. Make sure that third party warrants, as I think somebody mentioned earlier, that if they're using graphics, if they're using text that may be from other sources, they've got the necessary permission to do that, or that all the work is original to them and they have the right to assign copyright. You've got to protect yourself that way because, as we're seeing, very quickly, people are catching on to the potential for making money out of this beast. And they're not taking kindly to misuse of works. For example, that graphic you mentioned that had been taken by somebody, and that could have been a perfectly innocent taking. But somebody's going to get nasty about that at some point along the line.
Yeah. Netscape has something on their homepage that if you want to, as a lot of pages do, have a little message saying that the page was designed and is best viewed using the latest version of Netscape, Netscape being a link to go get a copy of it. There's something right on the Netscape homepage now where it's a little interactive thing where you fill in the form, and if you do that, you're allowed to take an icon and drop it onto your page to form the link. So.
As long as they allow you to do that, and you, for example, gave permission to everybody here to look at your sample homepage and do whatever they want.
Yeah, pilfer at will.
I do want to mention one further thing just before we close up, and that is fair dealing is an exemption from infringement. Nobody really knows exactly what fair dealing is. The only thing we do know is it probably doesn't apply to making a copy of an entire work for any purpose. But I'm making this point now because you're going to see a lot on the net about what's called fair use. This is the United States counterpart to our fair dealing. And fair use is much more liberal than fair dealing is in Canada. So do not do what these US FAQs and so on say you can do under fair use, because in Canada, most of that will constitute a copyright infringement. If you're interested, the section of the Act is referred to in my paper. Read what fair dealing applies to before you actually decide that what you're doing is fair dealing. Do you have any more questions? Yes?
I did want to follow the comment you made about the employees and non-employees for copyright. If you have employees in your firm that are computer literate and that are doing the work, are they themselves going to retain any copyright?
Absolutely, absolutely.
No, the Copyright Act specifically provides, in the case where the copyright is under where the author is under a contract of service, which is an employee, as opposed to a contract for services, which is a contractor, the first owner of copyright is the employer. And there are no moral rights attaching to the author in that case. So the employer could make whatever modifications they wish to the work. That's the only exception.
If the work was created in the course of their employment.
Right.
If the work, yes,
Do it
of
in
course.
your spare time?
If it's something that you're doing in your spare time, I think, yes.
So Rob's okay.
There you go.
Right.
Okay. I'm going to have to ask people to be able to buttonhole you. I guess at the end of this session, our time is out. I have to thank you've covered a particularly difficult area of the law very well. Michael, you too, covering a difficult area of security, something we've got to get our minds around, as foreboding as it seems. And Rob, your experience with the homepage has been very, very helpful. And Malcolm in absentia, thank you for your comments. We'll hang around for a minute or two if you have any particular questions. Otherwise, I thank you for coming. I hope you'll help me thank my speakers. Please don't forget the course evaluation. If you can just take 20 seconds and fill that out, you can leave them just outside the door.